So yes, as I said, I'm active both in Fridays for Future Estonia and also in this Estonian Environmental Law Center. So today I'll be talking about the first climate court case in Estonia and in the Baltics from both of these perspectives. But first of all, I'll just tell you a bit about what both of these organizations are. So Fridays for Future is part of the global movement with the same name that got started some 5 years ago. And the officially registered organization in Estonia has the name MTÜ Loodusvõlu. So it's a very Estonian name. But this is the official legal body that initiated the court case, but we did it as Fridays for Future as the movement in Estonia. And then Estonian Environmental Law Center is an expert organization that provides legal advice on environmental law matters, but also we engage in advocacy work for the protection of the environment. So I'll first tell you a bit about Estonia to give you some context for this court case, because I think parts of it are a bit specific to Estonia. So as you probably know, Estonia is this tiny little country, fairly far in the north. And although we are very tiny as a country and as a population, our contribution to climate change historically has been disproportionately high, as you can see on this graph. And most of our carbon emissions still to date come from the oil shale industry. So oil shale is a fossil fuel that is kind of like coal, except for that oil shale is far less efficient as a fuel. So to produce the same amount of electricity or energy from oil shale, you need to actually extract and burn much more of it than, for example, compared to coal. So the emissions are also higher. And most of our emissions come from this small region that is noted here on this map. And that is because the oil shale industry is located in that area. And this is also the focus of this climate court case. So it began in 2020 it happened to be during the COVID pandemic, when the government allocated some 125 million euros to the state-owned national energy company called Eesti Energia. And they engage in electricity production, and also they produce oil from oil shale. So oil shale is, in that sense, versatile, that it can be used both for producing electricity and also for producing oil. And this is an image of one of the existing plants from the construction site where this current plant is being constructed. So this plant produces oil that is, the far majority of it is exported, and it's exported even to outside the EU because it's so polluting that it doesn't comply with EU environmental regulation. And it's used either as ship fuel or sold as low-grade gas in so-called third world countries. If the plant is turned on and it begins operations, it will increase Estonia's national carbon emissions instantly by about 6%. And when the burning of the oil that happens abroad is also accounted for, its emissions actually double. So it is a major way of exporting our emissions. And this plant also creates some 61 jobs. So actually, it doesn't really that much help with alleviating the problem with lack of well-paying jobs in the region. So after the government made the decision to fund the plant, the local government, the local municipality of Narva-Jõesuu, issued it a construction permit very quickly. And then, first of all, youth organizations, scientists, and public figures all sent public letters to the government asking them to reverse the decision, but this didn't have any effect. So in the end, Fridays for Future, or officially MTÜ Loodusvõlu, decided to take the case to court. So we took the so what we focus on is the construction permit that was issued to this plant, and not actually the funding decision, because we didn't have any kind of standing to contest that. So we're focusing on the construction permit. Our main argument in the case is that constructing the shale oil plant is incompatible with alleviating the climate crisis. But also, we address some of the efficiencies in the environmental impact assessment, so that this relates to the small particles emissions, the management of phenolic water, which is a byproduct of producing oil from oil shale, also the lack of assessment of the plant's climate resilience, and impacts on Natura 2000 areas. One of them is really close to the site, some others are a bit further away. But more about the climate argument, because this was really the foundation of the case. So the relevant acts that we refer to are the Paris Agreement, the UN Development Goals, and some strategic planning documents that were in effect back then and mostly still are today. So to date, Estonia still doesn't have a climate act. So there are no climate targets that are specified in the law itself. So that's why we had to refer to the strategic planning documents, which are more of the soft law instruments. And this in itself was somewhat problematic because the municipality argued that they don't need to consider this because they're not actual law. And the main shortcomings that we argued in the environmental impact assessment were that, first of all, there wasn't a specific environmental impact assessment carried out, but instead they referred to the strategic environmental assessment that was carried out earlier, and which they claimed to have carried out with the precision of an environmental impact assessment. But we didn't agree with that. We found that too generic. Secondly, we argued that the assessment altogether excluded the emissions of burning the oil, so basically half of the emissions that are associated with the operations of this plant. And we found that very relevant because there isn't really anything else to do with this oil. So when the municipality issued the construction permit, they knew that it was going to be used to produce oil that is used to burn. So it can't be separated from the plant, we argued. And we argued that the climate impact that results from the operation of this plant is unacceptable because it doesn't, it makes it very difficult to comply with the targets in the Paris Agreement and in the other relevant acts that we referred to. The first small victory that we had was about a year after we submitted the complaint, and this was when the court temporarily suspended the construction of the plant. Because they found, we argued that the impacts on the nearby Natura 2000 area hadn't been properly assessed, and the court agreed with that. However, later on, the administrative court dismissed the complaint, and also they lifted the interim injunction, because in the meantime, they had carried out a rapid assessment and found there to be no significant impact. And then the circuit court also dismissed the complaint a year later, after which we took the case to the Supreme Court, who last year annulled the construction permit and stopped the construction of the plant. So the first climate court case in Estonia and in the Baltics resulted in a victory. However, when we look into what the court said, it was interesting that although the construction permit was annulled, it was not done on climate grounds. It was actually done because of the other deficiencies that we found in the environmental impact assessment. So the court ordered the municipality to assess these impacts as well, and then make a new decision on whether or not to issue the new construction permit. But still, the court elaborated in length on the climate impact of the plant and how it should be accounted for. So this has been very significant. So one of the important things the court said in this ruling was that the court stated that the climate impact of the plant that results from the operation of the plant must already be taken into account when issuing the construction permit. So the municipality and also Eesti Energia, the company, both argued that the climate impact that results from the operation is a matter for the integrated environmental permit that is issued later on. But the court stated that although, yes, finally the decision whether or not to allow the carbon emissions from the operation of the plant, that is decided with the integrated permit, a preliminary assessment already must be carried out beforehand, because the municipality shouldn't issue a construction permit to a plant that they already know that can't begin operation because of its large climate impact. Then the court also stressed that the climate targets included in strategic development documents are relevant and must be taken into account. So despite the fact that Estonia doesn't have a climate act, there are no hard law climate targets in Estonia, we still have some climate targets, and these must be taken into account. And regarding these climate targets, the court concluded that the assessment of the climate impact of the plant is limited by the scope of the national climate targets, because the court found that as there is no strict upper boundary of what is considered to be an environmental threat in the context of climate change, the court took the position that if the operation of the plant stops Estonia from meeting its national climate targets, then definitely this constitutes an environmental hazard or threat. But then the impact of the plant must be compared to the national climate targets. And as the national climate targets only are set for the Estonian national climate carbon emissions, then the broad emissions of this plant should not be taken into account. So this is why the burning of the oil and the emissions that result from this do not need to be assessed. I need to take a sip of water. Then the court also stressed that the risk of not obtaining an integrated permit lies solely with the developer. So if, for example, climate targets are made stricter during the construction process, and in the end they don't get an integrated permit, this is not a risk that the state or anyone else should carry. And they also went as far to say that there is no existential need to start the operation of the plant. And the court went even further and gave some general direction for Estonia's climate regulation. So they stated that Estonia has a constitutional obligation to make a proportional contribution to the achievement of the targets of the Paris Agreement. And this is very significant because it's the first time that the court in Estonia stated that really climate change must be taken seriously also in the legal sphere. And in the end, the court stated that without having a clear framework that sets out the final climate targets, interim targets, and so on, it can't be excluded that allowing such a climate-intensive, carbon-intensive installation infringes people's fundamental rights in other sectors in the future. But then, in the past half a year after the ruling, there have been some interesting developments with the case. So although we won the case itself, the municipality went on to issue a new construction permit after they assessed the environmental impacts that had been left out. They found there to be no significant impacts, and so the construction resumed. And now the plant is almost completed, but it is still unclear if it can begin operation. To enable it to begin operation, at least for a while, the government agreed to amend the law very rapidly last year to allow the plant to be issued an integrated permit with a deadline. So normally integrated permits are issued without a deadline indefinitely. But in this case, they decided to create an opportunity to also issue an integrated permit with a deadline, so that the plant could be given a permit to operate until 2035, which is the year when Estonia has its next national climate target. So the idea is that if the plant stops operation before 2035, it can't interfere with achieving that target, because that year it won't operate and it won't affect Estonia's carbon emissions. And so what's next regarding the plant and its future? The draft of the integrated permit was published on the 1st of April, and this includes issuing the permit until 2035, as I just explained. And the planned operation of the plant is planned to start operation later this year or earlier next year. But also, in the background of this, the climate act is being drafted with hopefully the first specific climate targets for Estonia as a whole, and also for sectors to be specified in it. But we're not yet sure how this is going to affect the operation of this plant. So this is an overview of the first climate court case in Estonia. Thank you, and I'm looking forward to your questions on this.